The Free Exercise Clause, common interpretation by Frederick Giddings and Michael McConnell. Many settlers from Europe braved the hardships of immigration to the American colonies to escape religious persecution in their home countries and to secure the freedom to worship according to their own conscience and conviction. Although the colonists often understood freedom of religion more narrowly than we do today, support for protection of some conception of religious freedom was broad and deep. By the time of independence and the construction of a new constitution, freedom of religion was among the most widely recognized inalienable rights, protected in some fashion by state bill of rights and judicial decisions. James Madison, for example, the principal author for the First Amendment, eloquently expressed his support for such a provision in Virginia. It is a duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. This duty is a precedent both in order for time and degree of obligation to the claims of a civil society. Although the original Constitution contains only a prohibition of religious texts for federal office, Article 6, Clause 3, the Free Exercise Clause was added as a part of the First Amendment in 1791. In drafting the clause, Congress considered several formulations, but ultimately settled on protecting the free exercise of religion. This phrase may explain the protection of actions as well as beliefs, but only those in some way connected to religion. From the beginning, courts in the United States have struggled to find a balance between the religious liberty of believers, who often claim the right to be excused or exempted from laws that interfere with the religious practices, and the interests of a society reflecting those very laws. Early state court decisions went both ways on this essential question. The Supreme Court first addressed the question in a series of cases involving 19th century laws aimed at suppressing the practice of polygamy by members of the Church of Jesus Christ of Latter-day Saints, LDS, also known as Mormons. The court unanimously rejected free exercise challenges to those laws, holding that the Free Exercise Clause protects belief, but not the conduct. Laws are made for the government actions, whether they cannot interfere with the mere religious beliefs and opinions, they may with the practices. Reynolds versus United States, 1878. What followed was perhaps the most extreme government assault on religious freedom in American history. Hundreds of church leaders were jailed, ranked foul Mormons were deprived of their right to vote, and Congress dissolved the LDS Church and expropriated most of its property until the church finally agreed to abandon polygamy. The belief-action distinction ignores the Free Exercise Clause offers protection of religious practice, but spoke to the concern that the following allowing believers to disobey laws that bind everyone else would undermine the value of a government of laws applied to all. Doing so, Reynolds warned, would be to make the professed doctrines of religious beliefs superior to the law of the land, and in fact to permit every citizen to become a law unto himself. Reynolds influenced the meaning of the Free Exercise Clause well into the 20th century. In 1940, for example, the court extended the clause which by its terms constrained only the federal government to limit the state laws and other state actions that burden religious exercise. Cantwell versus Connecticut, 1940. Though it recognized that the governments may not unduly infringe religious exercise, the court reiterated that the conduct remains subject to regulation for protection of society, citing Reynolds as authority. Similarly, the court held in 1961 Then the free exercise clause did not exempt an Orthodox Jewish merchant from Sunday closing laws against citing renewals. In 1960s and early 1970s, the court shifted, strengthening protection for religious conduct by construing the free exercise clause to protect the right of religious believers to exemption from generally applicable laws which burden religious exercise. The court held that the government may not enforce even religiously neutral law that apply generally to all or most of society unless the public interest in enforcement is compelling. Wisconsin versus Yoder, 1972. Yoder thus held that the Amish families could not be punished for refusing to send their children to school beyond the age of 14. Although the language's compelling interest test suggests powerful protections for religion, this was never fully realized. The cases in which the Supreme Court denied exemptions outnumbered those in which it granted them. Aside from Yoder, the court exempted believers from availability for work requirements, which denied unemployment benefits to workers terminated for prioritizing religious practices over job requirements. We denied exemptions to believers and religious organizations which found the religious practices burdened by conditions for federal tax exemption, military uniform regulations, federal minimum wage laws, state prison regulations, state sales taxes, federal administration of public lands, and mandatory taxation and other requirements of the Social Security system. In all of these cases, the court found, often controversially, either that the government's interest in enforcement was compelling or that the law in question did not constitute a legally recognizable burden on religious practice. In 1990, the Supreme Court changed course yet again, holding that the free exercise clause did not relieve an individual for the obligation to comply with the valid and neutral law of general applicability on the ground that the law prescribes conduct, and that his religion prescribes employment division versus Smith, 1990. You had to excuse me, my throat being coughing a little bit. So let's continue. Though it did not return to the belief-answering distinction, the court echoed Renard's concern that religious exemptions permit a person by virtue of his belief to become a law unto himself, contradicting both constitutional tradition and common sense. An exemption to religious neutral and generally applicable laws therefore must come from the political process. Smith went on to hold that the free exercise clause does not protect the sacramental use of peyote, hallucinogenic drug by members of the Native American Church. Smith proved to be controversial. In 1993, overwhelming majorities in Congress voted to reinstate the pre-Smith compelling interest test by statute with Religious Freedom Restoration Act, RFRA. RFRA authorizes courts to exempt a person from any law that imposes a substantial burden on sincere religious beliefs or actions, unless government can show that the law is the least restrictive means of furthering a compelling governmental interest. Almost half the states have passed similar laws. State RFRAs applicable to their own laws. In 1997, the Supreme Court held that the Congress had constitutional authority only to apply RFRA to federal laws and not to state or local laws. Congress then enacted a narrow law, the Religious Land Use and Institutionalized Persons Act, LUIPA, which applies the compelling interest test to state laws affecting prisoners and land use. RFRA and LUIPA have 40 exemptions in a wide range of federal state acts context, from kosher and halal diets for prisoners to relief from zoning and landmark regulations on churches and ministries to exemptions from jury service. Although some exemptions claimed brought under this religious freedom statutes have been relatively uncontroversial, the Supreme Court unanimously protected the right of a tiny religious sect to use a hallucinogenic drug prohibited by federal law, and the right of a Muslim prisoner to wear a half-inch beard prohibited by state prison rules. Some touch on highly contested moral questions. For example, the court, by a 5-4 vote, excused the commercial family-owned corporation from complying with the contraception mandate regulation, which required the corporation's health insurance plan to recover what its owners believe are abortion-inducing drugs. Burwell vs. Hobby Lobby stores in operation 2014. In the wake of Hobby Lobby, the court's subsequent determination that the state may not deny gay and lesbians the right to civil marriage, state RFRAs can become a flashpoint in conflicts over whether commercial vendors with religious objections may refuse their products and services to same-sex weddings. Besides RFRA and other exemption statutes, the Free Exercise Clause itself, even after Smith, continued to provide protection for believers against burdens on religious exercise from laws that target religious practices or that disadvantage religion in discretionary case-by-case decision-making. In Church of the Rukmini Babalu I.E. Incorporation versus City for Halil, 1993, for example, the court unanimously struck down a local ordinance against its unnecessary killing of animals in a ritual or ceremony, a law that was drawn to apply only to a small and unpopular religious sect whose worship includes animal sacrifice. The court recently recognized that the Free Exercise Clause, along with the Establishment Clause, require religious exemption from a neutral and general federal anti-discriminational law that interfered with the Church's freedom to select its own ministers. The court distinguished Smith on the ground that it involved government regulations for only outward physical acts, but this case concerns government interference with an internal church decision that affects the faith and mission of the church itself. Hosanna-Tabor Evangelical Lutheran Church and the School versus EEOC 2012. It remains unclear whether Rukmini and Hosanna-Tabor narrow exceptions to Smith's general presumption against religious exemptions or foreshadow yet another shift towards a more exemption-friendly free exercise doctrine. Manners debate. The first perspective. Religious liberty is an equal liberty, by Frederick Giddings. At the time the United States adopted the First Amendment to the Constitution, other nations routinely imposed disabilities on religious minorities within their borders, depriving them of legal rights, making it difficult or impossible to practice their faith, and often enabling violent persecution. The Free Exercise Clause is thus an exceptional political achievement, imposing a constitutional norm of civic equality by prohibiting the federal government from interfering with all religious exercise, regardless of affiliation. Only a few years before the First Amendment was ratified, James Madison wrote that all people naturally retain equal title to the free exercise religion according to the dictates of conscience, without the government subjecting some to peculiar burdens or granting to others peculiar exemptions. A memorial and Montserrat against religious assessments, 1785. Excuse me. As Madison suggested at the time the Constitution, the Bill of Rights were ratified, the guarantee of religious free exercise was understood to protect against government discrimination or abuse on the basis of religion, but not to require favorable government treatment of believers. In particular, there is little evidence that the founders understood the free exercise clause to mandate religious exemptions that would excuse believers from complying with neutral and general laws that constrain the rest of society. The Supreme Court has historically led the question of religious exemption to Congress and the state legislatures. The first judicial ordered exemptions arose in the 1960s, the early 1970s, when the Supreme Court held the free exercise clause required religious exemption for Amish families who object to sending their children to high school, and for employees who were denied unemployment benefits when they lost a job for refusing to work on the Sabbath. This doctrine for judicial ordered exemptions, however, was an historical aberration. Employment Division versus Smith, 1990, the court considered a claim by members of a Native American religion who lost a job as drug counselors for using a illegal drug in a religious ritual. The court abandoned its new doctrine of religious exemptions, ruling that the free exercise clause did not grant the believers a right to exemptions from religious neutral, generally applicable laws, though legislatures were free to grant such exemptions if they wished. This relegation of exemptions to the political process in most circumstances returned the free exercise clause is a historical baseline. Notwithstanding the narrow ministerial exemptions recognized in Hosanna-Tabor Evangelical Church and the School versus EEOC, 2012, the court repeatedly affirmed the Smith and the Center for President decided that in that case, it has shown no inclination to overturn its basic principle that neutral and general laws should apply equally to all, regardless of religious belief or disbelief or unbelief. The growth of social welfare entitlements and religious diversity in the United States had underscored the wisdom of the Smith rule, exempting believers from social welfare laws may give them a competitive advantage and also may harm those whom the law was designed to protect or benefit. For example, the court refused to exempt an Amish employer from paying Social Security taxes for his employee, reasoning that doing so would impose the employer's religious faith on his employees by reducing the Social Security benefit regardless of whether they share the employee's religious objection to government entitlement programs. United States versus Lee. Similarly, the court refused to exempt the religious employer from federal minimum wage laws because doing so would give the employer advantage over competitors and depress the wages of all employees in local labor markets. Tony and Susan Alamo Foundation was the Secretary for Labor, 1985. The court seemed poised to adopt the third-party burden principle in decisions interpreting the 1993 Religious Freedom Restoration Act, RFRA, as well. 5 justices in Burwell versus Hobby Lobby Stores Incorporation, 2014, expressly stated that RFRA exemption posing significant costs on others are not allowed. The majority opinion likewise acknowledged the courts must take adequate account of a third-party burden before ordering RFRA exemption. The growth of religious diversity makes the religious exemption regime doubly impractical. The vast range of religious beliefs and practice in the United States means that there is a potential religious objector to almost any law the government might enact. If religious objectors were presumptively entitled to exemption from any burdensome law, religious exemptions would threaten to swallow the role of a law, which presupposes its equal application to everyone. At the core of observingly, a religiously diverse social welfare state cannot show every person more the burden incident to exercising every respected right to practice religious beliefs. Even under the equal liberty regime contemplated by the founders and restored by Smith, government remains subject to important constraints that protect religious liberty. Religious gerrymanders, or laws that single out particular religions for burdens not imposed on other religions or on comparatively secular conduct, must satisfy strict scrutiny under the Free Exercise Clause. Church of the Kimi Blalu, i.e., in cooperation with City for Haile, 1993, Shabert versus Werner, 1963, under IFRA, and Religious Land Use Institutionalized Persons Act for 2000, RLUIPA, the federal government and often the state governments are prohibited from burdening religious exercise without adequate justification. Holt versus Hobbes, 2015, Gonzalez versus O Centro Espírita Beneficente União do Vegetal, 2005. And like judicially ordered exemptions, legislative exemptions that impose material costs on others in order to protect believers' free exercise interest may be invalid under the Establishment Clause, which protects believers and unbelievers alike from bearing the burdens of practicing someone else's religion. It's cited for Thornton versus Kelder, 1985. Exemptions are to be afforded to those whose religious practice are burdened by neutral and general laws. They should generally not be granted by courts, but by the political accountable branches of the federal and the state governments. These branches are better suited to win and balance competing interests of believers and others in a complex, religiously diverse society. Next perspective, free exercise, a vital protection for diversity and freedom, by Michael McConnell. One of this nation's deepest commitments is to the full, equal, and free exercise of religion, a right that protects not only believers, but unbelievers as well. The government cannot use its authority to forbid Americans to conduct their lives in accordance with their religious beliefs or to require them to engage in actions contrary to religious conscience, even when the vast majority of their countrymen regard these beliefs as backward, mistaken, or even immoral. Unfortunately, in the last few years, especially since the Supreme Court decision requiring states to recognize same-sex marriage, this consensus in favor of tolerance has been slipping. All too often, we hear demands that religious people and religious institutions, such as colleges or adoption agencies, must join the state in recognizing same-sex marriages or performing abortions or supplying contraceptives or whatever the issue happen to be, or losing the right to operate. That has not been the American way. When this country severed its tie with the British Empire, one thing went with it, with the established church. To an unprecedented degree, the young United States not only tolerated, but actively welcomed people of all faiths. For example, despite his annoyance with the Quakers for the refusal to support the Revolutionary War effort, Washington wrote to a Quaker society to express his wish and desire that these laws may always be as extensively accommodated to them as a due regard for the protection and essential interests of the nation may justify and permit. Letter to the annual meeting of Quakers, 1789. What would it mean to have a regime-free exercise religion? No one knew. there had been no such a thing before. It quickly became clear that it was not enough just to cease persecution or discrimination against religious minorities. Just 2 years after the Ying, with the drawing of the First Amendment, the leader of the Jewish community in Philadelphia went to court and asked on the authorities of the state's free exercise clause to be excused from complying with the subpoena to appear in court on his day of the Sabbath. He did not ask that the state cease to do official business on Saturday, but he did ask the court to make exception, accommodation that would enable him to be faithful to the Jewish law. This would become the central interpretive question under the Free Exercise Clause. Does it give Americans whose religions conflict with government practice the right to ask for special accommodation, assuming accommodation can be made without great harm to the public interest or the rights of others? In the early years, some religious claimants won and some lost. The Mormon Church lost in a big way. The first such case to reach the United States Supreme Court, Reynolds versus the United States, 1878. In 1963, the Supreme Court held that the Free Exercise Clause of the First Amendment does require the government to make accommodations for religious exercise, subject as always to limitations based on the public interest and the rights of others. Sherbert versus Werner, 1963. In 1990, the court shifted to the opposite way. In the case involving the sacramental use of payout by members of the Native American Church, Employment Division versus Smith, 1990. Today, we have a patchwork of rules. When the federal government is involved, legislation called Religious Freedom Restoration Act grants us the right to seek appropriate accommodation when our religious practices conflict with the government policy. But the heads of state have similar rules, and similar rule protects president like the Muslim president who recently won the right to wear a half-inch beard in accordance with Islamic law by a 9-0 vote in the Supreme Court. Holt versus Hobbs, 2015. The range of claim has been as diverse as the religious demographic of the country. A small Brazilian sect won the right to use hallucinogenic drug in worship ceremonies. Amish farmers have won exceptions from traffic rules. Muslim soldiers have been given special accommodation when fasting for Ramadan. Orthodox Jewish boys won the right to wear the skull caps when playing high school baseball. A Jehovah's Witness won the right to the unemployment compensation after they quit rather than working to produce doctorants. A Mormon acting student won the right to refuse rules involving nudity or profanity. And in the most controversial recent case, a family-owned business with religious objections to paying for abortion-inducing drugs persuaded the Supreme Court that the government should make these contraceptives available without forcing them to be involved. In all these cases, courts or agencies came to the conclusion that religious exercise could be accommodated with little or no harm to the public interest or to others, as Justice Sandra Day O'Connor, joined by liberal lines Brennan, Marshall, and Blackmon, wrote, courts have been quite capable of applying our free exercise jurisprudence to strike sensible balances between religious liberty and competing state interests. Employment Division versus Smith, 1989, concurring opinion. In a time when the Supreme Court same-sex marriage decision has allowed many millions of Americans to live their lives in accordance with their own identity, it would be tragic if we turn our backs on the right to live in accordance with our religious conviction, which is also part of who we are. A robust protection for free exercise religion is not only part of the American tradition, it is vital to our protection for diversity and freedom.